Good evening, or good morning, good afternoon. Sometimes there's some people who just really manage to annoy the living shit out of me. And like broken system, broken trust just annoys the ever living piss out of me. He's wrong. He's terminally wrong. And you can show it to him over and over again. And it's just like he'll walk down the path with you and then he'll just flip and he'll be right back at square one. Like like you never like the conversation, like all of the steps from you go A, B, C, D, E, F, G, and then bam, he's back at A. And you're like, don't you remember we went B, C, and it just misses it. Just and I don't, you know, I'm not smart enough to know if it's intentional, if it's just that they're just not smart enough to figure it out. Rogue Nation is another person who just like he's just one of those guys. Like he'll take a picture, his video will display posted notices that you can't record in, for example, a Social Security Administration building, and he'll be like, "Show me the policy that says I can't record." And be like, it was posted to. Well, my lawyer and I can't find the policy. It was your camera literally recorded it, and it's like a complete inversion. There was a time when people were like, "Show me the sign." There has to be a sign that says I can't record. You can't just tell me I can't record. There has to be a sign. And now like the script is flipped, and because they're signs, and it's absolutely amazing. Story time. Here's story time for you. I am representing a client on a civil harassment restraining order. He's the defendant, and I want to say like Monday. Monday was the hearing. Was the hearing on the restraining order, and the judge took the testimony from the petitioner, and I presented missing texts from her, screenshots of texts, and poked holes in her little story, and explained the law, explained the burden of proof, that it was clear and convincing evidence, that she failed to, with specificity, even allege all these acts, and why they meet the definition of harassment. I explained why my client had a legitimate reason. I walk down the primrose path, and the judge, there's, just for context, there's a civil harassment restraining order, a guardianship, and a domestic violence restraining order that all involve three people. And they all got consolidated: a father, a son, and a proposed guardian. And so they got consolidated, and before I got into the case, so it all got assigned to a family law judge. And so I'm breaking it out, and I only was willing to proceed on the civil harassment one first, because that was their weakest case against my client. So anyway, she takes the testimony. She takes a recess to go review the books, and then she comes out, and she ends up granting a temporary restraining order. And I'm just baffled at this point. I asked for a statement of decision, and she explains why she's doing it. I said, "Yeah, I don't understand what the authority you have to do that is, because a temporary restraining order issues, like that's what you start the process with. We just had a hearing. It's a different standard of proof, yada yada." And she explains why again. I'm like, I don't understand. I don't understand your authority to do this. I'm asking for a statement of decision. She said, "Fine, I'll give you the statement of decision, but it's going to be exactly the same as what I just told you." I said, "That's fine, because as long as I get a statement of decision, I can appeal if I have to." Anyway, her clerk called today, and said, "Mr. Rietveld, are you are you available to come in tomorrow for a hearing on reconsideration? The court sua sponte, when she went to go do her statement of decision, she figured out that she sure as shit didn't have the jurisdiction to do what she was going to do. Now, that doesn't mean my client's going to win, because it's going to go one of two ways. She knows she didn't have the jurisdiction to do what she wanted to do. But if she goes ahead and says, like, I find that the petitioner proved by clear and convincing evidence that that there was harassment, then what are you going to do, right? But anyway, back to the topic. Now that we've had people filter, and now that we've had story time, I saw this from Rogue Nation, and the guy is just a fucking moron. Like, he's about the stupidest thing on 2 feet that I've ever seen. He rivals Broken System, Broken Trust for stupid. It's amazing. Fucking amazing. So he says, Merv, saw your video today, thought it was well done. Thanks, buddy. Like, your opinion matters to me. Was wondering if those terms have been defined in a right to record case and not a libel case. Well, here's the weird thing. Like, I first read this and I'm like, a right to record case is a First Amendment case, and a libel case, like, for example, the New York Times versus Sullivan, isn't a libel case. I mean, it is a libel case, but there's a reason why it's in front of the Supreme Court of the United States and not in front of the state Supreme Court, because you have to remember that libel, slander, defamation laws in general are state causes of action. They're not federal causes of action. So sure, Linda, a lot of them do. But on the case at hand, the reason why it was in front of the Supreme Court was because there was a First Amendment. There's a First Amendment aspect to it. So it wasn't a libel case in front of the Supreme Court. The Supreme Court was looking at it as under the First and 14th Amendments. It's a First Amendment case. 14th Amendment is just there to apply it to the states. It's a First Amendment issue. It's a First Amendment issue. So right to record is a First Amendment issue, and libel is a First Amendment issue. So my first thought is, obviously, you're a fucking moron. But, well, you know what? I will play your game. I will play your game. This is Martin v. Gross. This is literally a right to record case. They're challenging a Massachusetts general law about recording. This is a right to record. The statute does not apply to open, non-secret recording, blah, blah, blah. It's a right to record case. Just as much as other cases in the First Amendment, the First Circuit were, like Garricky and Glick and Ayakobuchi, something like Ayakobuchi. So down here it says, moreover, there's a definitional issue with Glick's use of the term government official. Glick, Garricky, and other cases cited therein teach that a police officer falls within the ambit of government official. But who are these other government officials? The First Amendment doctrine, public officials may provide some guidance. See, e.g., Magwal, describing how definition of public official is evolved to include many government employees, including police officers. Well, what's Magwal? Because right, we're in a right to record case here that our boy Rogue Nation wanted to talk about. And 6566, this is the citation. Magwal v. Rotger Savat. What kind of a case is Magwal versus Rotger Savat? It is a defamation case. Libel case. Boom. And again, why is it in front of a federal court? Well, because there's a First Amendment issue. See, they're talking about actual malice. We're talking about New York Times. It's almost like I know what I'm talking about. And here the court defined, they're talking about New York Times. The court defined public official narrowly. The employee's position must be one which would invite public scrutiny and discussion of the person holding it, entirely apart from the scrutiny and discussion occasioned by the particular charges in controversy. In practice, this term is now used more broadly, includes many government employees, including police officers. So it's been applied to a deputy sheriff, an FBI agent, a police officer, and a federal narcotics agent. These are all, as you can probably gather, police officers. Courts later extended the actual malice protected speech about public figures as well as public officials. Now, why would they have to do that? Yeah, blah, blah, blah. Not going to go into that. Oh, shit, I'm not showing it. There you go. There you go. This is it. So this is an actual malice standard. This is the Magwell case. That wasn't showing, but should have. But here you go. You can see it. You can see it right here. So even a right to record case like Martin v. Gross sends you to another First Amendment case, i.e., a libel case. So next, also, did this case really extend the definition of public officials to those who work for elected officials? Rosenblatt v. So I guess we could look at Rosenblatt. Now, we could just look at, I'm sorry, we're looking here. Also, did this case really extend the definition of public officials to those who work for elected officials? And he pops up this. In Rosenblatt v. Blair, the court elaborated that public officials include not just those in elected positions, but those who work for elected officers. The court extended the actual malice of Times versus Sullivan to public figures, the courtesy public, blah, blah, blah. So he's asking about Rosenblatt v. Baer. And well, gosh, what is the citation here? The employee's position must be one which would invite public scrutiny and discussion of the person holding it, entirely apart from the scrutiny and discussion occasioned by the particular charges and controversy. The employee's position must be one which would invite public scrutiny and discussion of the person holding it, entirely apart from recording it and causing that person to come unglued. You can't turn a public employee into a public official just by recording them and eliciting a reaction. And it's citing Rosenblatt versus Baer. So yes, it does extend it. It does extend it, but it doesn't extend it to all employees, which is why in the video, I said, generally speaking, it applies to elected officials, generally. But I think Rogue thought he was scoring some points here because you can just tell he's madly Googling. These are all a few minutes apart, etc. He says also the cops in the 11th Circuit case, Smith versus Cumming, were referred to as public officials. Was the 11th Circuit just referring to the elected sheriff? No. Let's take a listen to what I said.
A sheriff is a public official. Now, police are public officials.
And then I go on to explain why they're public officials. So again, what kind of point was he making? Then he says, this is the definition per Congress. A public official is elected or appointed official or an employee of federal, state, or local government in the United States. There are 5 exceptions to this definition, including a college or university, a government-sponsored enterprise, a public utility, guarantee agency, or agency of any state functioning as a student loan secondary market. The 1998 amendments to the LDA expanded the definition of a public official in Section 3115F to add a group of governments acting together as an international organization. Its purpose was to ensure those international organizations, such as the World Bank, would be treated in the same manner as the governments that comprise them. This is a weird thing to cite. And Section 315F? Section 315F? Well, this is obviously a citation to a specific U.S. Code section. Well, here's Section 315F. U.S. Code 1602, Section 3. $15F. National, regional, or local unit of any foreign government or group of governments acting together as an international organization. A group of governments acting together as an international organization. I think this is what they're talking about. And it's the LDA, huh? So we're in, I'm in 2 USC 1602, Chapter 26, Disclosure of Lobbying Activities, Title 2. Is about lobbying. Where were we? Lobbying Disclosure Act, the LDA. The Lobbying Disclosure Act. So when you look at definitions, it says, it starts off this section as used in this chapter. In this chapter. So the definition, actually, let's go to this one. This is the definition per Congress. It was the definition per Congress for that specific chapter of 2 USC. Then he says, here is your state statute defining the term. So this motherfucker is just Googling away. Here's your state statute defining the term. And it's California Government Code 82048. Why would the state statute matter? We're talking about First Amendment stuff, right? Why would the state statute matter? Can the state regulate away First Amendment rights? But here's that particular section. Public official means every member, blah, 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 right? But we're in a specific place, Chapter 2, definitions. Let's look at Chapter 2, Chapter 2 definitions. Unless the contrary is stated or clearly appears from the context, the definition set forth in this chapter shall govern the interpretation of this title, i.e., these definitions only apply to Title IX, political reform. Shit, you didn't see any of that. Political reform. There's your 82408. It's in Title IX, political reform. It's in Chapter 2, definitions. That's contrary stated or clearly mixed up. Just for the title. Just for the fucking title. So it's not my state statute defining the term. It's a state statute defining the term for the purpose of a particular title. Here's the federal code definition. He's so dumb, he doesn't even realize that this is quoting the same 2 USC 1602 that he previously posted, because this dumb motherfucker doesn't know that the lobbying LDA, the Lobbying Something Act, Lobbying Disclosure Act. That's what it is. The Lobbying Disclosure Act. He's so dumb that he doesn't even realize that he'd already posted this. So he posted it again. Then he goes on to say, courts in a few states have ruled that teachers are public officials. Who the fuck cares? Who the fuck cares? Again, can a state change First Amendment law? No, it can't. Well, let me rephrase this. The state can probably increase exposure if the state designates a teacher as a public official. Then I don't know. The standard still applies. The Rosenblatt definition is still controlling. The person's position must be one which would invite public scrutiny and discussion of the person holding it. So the federal court, I don't think, would be bound by the state's definition. And I don't know in what context. I'm not going to look it up. I don't really care. I'm not going to really look up what context that the Connecticut Supreme Court made that ruling on. But it's just stupid. All right, I'll go through some. You guys are talking about other things. All right. What's up, freaks? Hello, Neil. Yay. Good evening. Good evening. You can't triple stamp, double stamp. That is correct. Assholes ask for advice and do the opposite. Or they'll argue with you once you give them the advice. Like, bro, if you already had the answer, then why are you asking me for advice? Yes, there are issues indeed. Yes, GD, we are freaks. And Rogue is a fool. So is Rouge. Yes, some cases break my heart to hear. Okay. Yes, he is. Well, I saw that. Something about like he's drafting his own signs that say he has the right to record, like this shit right here. The signs just like that I hung up that said recording is allowed, has the same DHEC symbol on it and everything. This mother, oh Jesus Christ. Here's some fun. This is a fucking hoot. Look at this motherfucker. His civil case. Oh, talk about he's gonna need to do an instant amended complaint. He violated my First, Fourth, and Fifth Amendment rights, as well as committing prior restraint and First Amendment retaliation. Why didn't you include the 14th Amendment there, you dumb shit? I want punitive damages, $200,000. It was willful and knowingly violation of my rights. I had the law in my hand, and he refused to read it or even understand. Why do auditors think that they are in a position to educate the cops? Like, imagine if any suspected criminal was able to be like, excuse me, officer, I think you misunderstand the law. Allow me to present these materials for you to read right now. And argue my case as to why your understanding of the law is incorrect. When asked to provide statute numbers of the laws he was claiming applied, he refused to do so. Well, I don't think he has an obligation to do that. I mean, I'm not a big fan of cops, but come on. So good old Georgie was in Barnville to record the public employees. of the Southampton or the South Carolina Hampton County Health Department. Having arrived close to the end of the day, there was no citizens in the lobby. There was no. Is educated. You know, the fun fact: Rogue Nation claims to have a 136 IQ, and he says things like, "There was no citizens." Within 2 minutes of me entering the building, I was accosted and told I was not allowed to film. At 7 minutes into the video, I walked outside to continue filming through the window as they were closing for the day. That's normal activity. That's what we should have people doing. Just filming through windows. At 8:27, well, he doesn't say what time he starts, so you know, there's no indication of what time he started. So we have 2 minutes after he entered the building. Okay. No idea what time he entered the building. At 7 minutes into the video, no idea what time he started filming. At 8:27 a.m. or p.m., who knows? Oh, 8:27 in the video. So another minute and 27 seconds after he starts filming through the window, a police officer arrives to tell him he's not allowed to record in the building. After arguing for about 30 minutes or 30 seconds, let's say 30 seconds, Officer Smith states, I need to show him something that says I can record or else I have to leave or face arrest. At 9:10 in the video, Officer Smith instructs me to shut down my video recording, comma, capital L. Lucky for me that my body cam was running and he didn't notice it, or else I wouldn't have been able to catch his later violations. At 11:33 in the video, he threatens me with arrest if I don't provide physical ID. At 13:54 or 13:45 in the video, he threatens me with arrest for taking the fifth and not answering his questions. Well, did he arrest you? He instructed you to shut down your video. You did it. Like, he didn't stop you from filming. He convinced you to stop filming. Oh, he did unlawfully seize my ID. Interesting. Did he reach into your pocket? Did you have a rocket in your pocket? Trespassing statute doesn't apply to public property. I refuse to believe that there's not a trespassing statute in South Carolina that can't apply to a public health. The Hampton County, I assume. I mean, there has to be. And if it's a health department, wouldn't they deal with like HIPAA shit? I don't know, man. Anyway, the guy's fucking dumb. Oh, none of you could see any of that. That's a good thing, because there was some addresses and shit early. It's late. I'm tired. I get up at 3 a.m. It's like 8:48. I don't have a heart unless it's a dog. My heart is not a dog. Rogue is going to jail? Maybe. Probably not. Honestly, he'll probably just catch a fine. Like, you've seen the Kim Blandino hearing on our Nevada judges. He's a first-year family dog attorney. A dog attorney, nice. Learn something new every day, Michelle. He is an idiot with allegedly 136 IQ. Dying. I post it in the main chat of my Discord. Woohoo! I would like for you to invite a constitutional law scholar like Delete Laws on one of your streams sometime. I would love to hear you debate someone who knows constitutional law. You know, legal debate doesn't really work well without a judge. You need to have a judge. You need to have someone there who actually knows the law to judge it. And DeCastro doesn't think judges know the law, so who we have judge whether or not any one of our legal arguments is correct. I think the best metric of knowing who understands the law and who doesn't understand the law is doing what I've been doing and making calls on how things are going to shake out. And if you're right, that means you have a good grasp of the law. And if you're not right, that means maybe you don't have a great grasp of the law. A constitutional law scholar. Smoked ribs. I grilled chicken tonight, and I grilled tri-tip last night. I've just been a grilling machine. Constipational. Who knows? Chili's a dunce cap. When will the debate with Rogue happen? It already happened. Well, I wouldn't call it a debate as much as a spanking, but he was very nice. He's like on the video, he's very nice. Like when we actually were on Zoom together, he was polite. Yeah. I'm not discording. How about Chili debate a real, educated, genuine constitutional law professor who actually knows the law? Chili would just say that professor doesn't know the law because of some random factoid about some New York cop who wrote a thing about something. Like, who fucking knows, dude? Chili doesn't play by the rules. He claims to be an expert in something that all of the recognized experts disagree with him on. So what are you going to do? It's like Chili and how many feet he's going to stand from an officer. Yeah, there's no case law that says what that distance is. Rift man, hell yeah, brother. Chili will just make shit up. Chili memorized some cases and added conspiracy theories. He sure did. What's up, Bandit? There's a ton of narcissistic grifters online. Hell yeah. Well, good for you to read Cliff Notes. I hope they were the right Cliff Notes, I guess. Chili is just the most narcissistic and biggest pathological liar we've ever seen. He doesn't know. You're elevating him to a status that is far above him. He's pretty mediocre in a lot of ways. But thank you, Nasty Nate. So many people do that with murder. They ask you for your opinion. Yeah, I know. Do you have blue bacon in a tank in your basement? I don't have a basement, nor do I have blue bacon in there. He is doing his own thing. Well, great. I'm glad I am a breath of fresh air. I feel like I should shower after hearing that. Smart folks can act stupid, but dumb folks can't act smart. That is correct. 132. All right. Such creeps. Why do these auditors think they know the law so well? Is it simply them hearing shit on YouTube and repeating it? Yes. It's the Dunning-Kruger effect. The less you know, well, first of all, some people are incapable of knowing. They will hear something and internalize it, and now they know it. That's a thing they know. And they'll over apply it to situations it doesn't apply. They aren't able to look at the nuance. They aren't able to distinguish it. It's just something they know, and they'll apply it over and over and over again because it's simple. It's bright line rules. It's easy for them. They don't have to think about it. They know this fact, and boom, it's easy. And all of the YouTube auditors, they all have these bright line rules. All of them do. That don't take the circumstances into account. It's just, here's the rule. I've learned the rule. And now I'm just blah. And they can't apply, they can't take into account any other changes to, like with Stout. as stupid as the quote debate with him was, if you saw, I started trying to ask him hypotheticals. He was taking the forum analysis from a single district court case in Florida, and he was applying it to every town hall in the entire United States. Every town hall, according to Stout, every inch of every town hall, according to Stout, is a limited public forum. And so I started asking some hypotheticals. What if this happened? What if this happened? What if this was going on? And he's like, I refuse to extrapolate from this. I refuse to look at. He literally said, I can't. All I could stay with is just the facts of this case. And what he didn't understand, which is why debating it was just so nonsense in the first place, he didn't understand that he was, in fact, taking the facts of one case and extrapolating it out to every other town hall in the United States. But he would refuse to look at the individual facts of a town hall. So, no, not everyone. Not everyone. Like Michelle doesn't annoy the piss out of me. Cops can lie, and they do lie. What's up, Eric? Logan Sandman. Just like when they say that's unconstitutional, they are in no position to make that claim. Generally speaking, they have no idea whether or not something's unconstitutional. And that's blatant. Discussing law to be the judge? No. It's not like you ever graduated basic training. Wow. Okay. A first-year constructional family attorney. I do an unfortunate amount of construction litigation right now. Yes, and it takes a lot of time, and it's very annoying and tedious. And I picked up, ooh, nice. He is sassy. There's a few houses around. There's some houses in Lincoln that I saw, like old Lincoln, that have basements. We were talking about Rogue Nation. Yes, he is a great legal mind, according to Stout. If you only get to collect dash under 22 enough gravity to find boobs and cut off shorts. Let's just for the sake of argument, just say over 18. Add that in there. How about that? You saw South Carolina and thought it might be. So yeah, Rogue Nation likes to travel, and yeah, he's got a lot of cases all over the place. I believe that he intends to make a living by having lots of 1983 lawsuits and collecting small settlements. That would be my best guess. Oh, good luck for the puppy. It's adorable. Bob the Scumbag Builder case. I don't know Bob the Scumbag Builder. Good luck. Thought so. Changing the subject. De Castro's answer in the LV MPD civil case is due on the 26th of January, but there is none. He has retained a lawyer. So do you have an opinion as to what is going on? The lawyer missed the deadline. That's my opinion. That would be my opinion. There may be some behind the scenes negotiations going on, but yeah, my opinion would be the lawyer missed the deadline. It happens. Sometimes lawyers miss deadlines. Anyway, that's the last one for the night. Thanks for watching. Have a great evening.